What does the probate process look like in Georgia? Hi, I'm estate planning and probate attorney Zack Beck with Peach State Wills and Trust, a division of the Beck Law Firm LLC here in Lawrenceville, Georgia, and we'll answer that question in today's video. So, what does the probate process look like here in Georgia? Well, it's important to note at the outset here that there's not one singular probate process that will occur for any given deceased person's estate. There are numerous different processes and procedures that may be useful and may be employed depending upon whether the decedent had a will, what their asset situation looks like, who the heirs are, and how much debt the decedent may have had. Generally, there are three main processes that get employed often here in Georgia, and that's what we're going to talk about today. Those are when the decedent had a will and we're simply probating that will and following it, when the decedent didn't have a will and we're going through the probate process with an administrator and dividing the assets amongst the heirs at law, and the third is what's called a petition for years support, which can be used to provide a year's support for the spouse or minor children of the decedent. Starting with the petition to probate a will and the petition to probate an estate where there is no will, either the executor nominated in the will or an administrator, who's typically going to be selected by all of the heirs or be an heir themselves, is going to petition to open the estate. The proposed personal representative will either seek letters testamentary if there is a will, or letters of administration if there's not a will. And in that petition, they'll give the court details, information about the known heirs of the decedent. Additionally, if there's not a will and the petitioner is seeking letters of administration, they'll have to provide some information on the assets of the decedent as well. Once the court receives the petition, assuming no objections are made, they'll issue either letters of administration if there's not a will, or letters testamentary if there is, to the personal representative. And if all of the heirs have consented, or if the will has provided that these requirements are waived, the court may further waive the requirements of bond, inventories, annual reports, returns, and statements. Then, the process whether there is a will and whether there's not a will looks quite similar. The estate's representative will marshal together all of the assets, they'll run a notice to debtors and creditors in the county newspaper, and they'll then pay off any valid debts. They'll then move to distribute any remaining assets. When there is a will, the will is going to control where those assets go, and the executor simply follows the directions that the decedent laid out. When there's not a will, Georgia's laws of intestacy are going to control. And those laws provide that if the deceased person left behind a spouse and had no children, everything that's left is going to go to the spouse. If they had a spouse and children, then the spouse and the kids split evenly, provided that the spouse gets at least a third of the estate. So if you had 3 kids and 1 spouse, the spouse gets a third, the 3 kids split the remaining 2/3, each getting, for example, 2/9. If there's no surviving spouse but there are children, the estate is split between the children and any descendants of deceased children. From there, we move out to more remote degrees of kinship, like parents and then siblings and nieces and nephews, out to grandparents and then cousins, and further on out. Now, I mentioned one more unique probate process that's commonly employed here in Georgia, and that's what's called the petition for years support. And what that petition does is allows the surviving spouse or any surviving minor children of the decedent to skip the line and get paid money to be supported for a year ahead of some of those creditor claims. So this procedure is typically only employed when the only heir is a spouse or a minor child, and we can just use this procedure to request the entire estate and not have to open a formal probate. Or second, when the decedent had significant debt and there wouldn't be any money left for the spouse or the minor child after we pay off all the creditors. So here, what happens is the petitioner fills out a petition and seeks certain assets from the estate to be used as a year's support. And they can do this whether or not there was a will. However, in a will, gifts made in the will can be structured so that they're in lieu of a year's support, and such that the spouse or the minor child left behind has to make an election between the two. The purpose of this procedure is literally to provide a year's support, that is, financial support for 12 months for the spouse or the minor children following the decedent's death. In practice, however, spouses and minor children can request as much property as they want from the estate. The court isn't going to make them outline in the petition why it's only needed for 12 months. If no creditors object, the court will award all of the requested property. If creditors do object to the amount requested, then there's a hearing that goes on, and from there, the court determines what's a fair amount to provide support for a year for the people requesting it, and what, if anything, should be used to pay off creditor claims and go to the other heirs. So that's an overview of the three main probate processes that we have here in Georgia. There are other more nuanced processes that happen in some situations, like procedures to open a safety deposit box, appointing testamentary guardians, things like that. For more information about probate here in Georgia, check out our YouTube channel, visit us online at peachstatewills.com, or give us a call at 678-344-5342.